Welcome back to Singapore Property Talk Law.
Great to be here.
Today, we're diving deep into something, well, super important if you have a housing loan here in Singapore. We're talking about understanding the rights and, yes, also the obligations of your mortgagee.
That's right, the bank or the lender who gave you the loan.
Exactly. We want to break down what they can and can't legally do here in Singapore.
It's crucial stuff.
Absolutely. And, hey, before we jump in, if you find this helpful, please do give us a like, hit that subscribe button too.
Yeah, so you don't miss our future deep dives on Singapore property matters.
Our mission today, pretty simple, really. We want to give you a crystal clear understanding of where your mortgagee stands.
But without overwhelming you with all the legal jargon.
Exactly. Okay, let's unpack this then.
Sounds good. So when you take out that housing loan, you sign a mortgage agreement.
Right.
That document, along with Singapore law, really sets the ground rules for both you and the lender. What you can do, what they can do, responsibilities.
Makes sense.
So let's start with maybe the biggest one, a really significant right the mortgagee usually has. It's called the power of sale.
Power of sale. Okay, that sounds pretty final. What does that actually mean for the homeowner?
Well, in essence, if you fall behind on your mortgage payments, you default. The lender typically has the authority to sell your property.
To sell my home.
Yes, to recover the money you still owe them. This right is often spelled out right there in the mortgage agreement itself.
Okay.
But even if it's not explicitly written in your specific agreement, Singapore law actually implies this power.
It does. How?
Through something called the Conveyancing and Law of Property Act. You can think of it as the main rule book for property stuff here.
Oh, the CLPA.
Right, the CLPA. It implies the power if your mortgage is set up as a deed, which is the standard formal way. And even common law recognizes it.
So if I hit a rough patch, maybe miss a couple of payments, they could just sell my home. That's quite worrying, actually.
Well, they do have the power to do it, yes. But there are important safeguards. The mortgagee has what's called an equitable duty.
Equitable duty.
Think of it like a duty based on fairness. They have to take reasonable steps to get a proper price for the property.
Okay.
A proper price at the time they actually sell it.
Okay, that sounds a bit better.
Yeah.
So they have to try and get a fair market price.
Yes, but here's the really crucial distinction. The focus is on the process they follow for the sale.
The process.
Yeah.
Not the price itself.
Exactly. Did they make reasonable efforts? Did they advertise it properly? Did they conduct the sale fairly to get the best price they could realistically achieve at that specific moment? It's not about guaranteeing the absolute highest price possible or about the timing of the sale.
Right. So they don't have to wait.
Generally, no. They aren't required by law to wait for the market to magically improve or delay the sale just to hope for a higher offer later on.
I see.
And they usually don't need to consult you, the borrower, on when they decide to sell or how they decide to sell it.
So even if the property market is, not doing so great, they can still decide, right, we're selling now.
Generally, yes. Remember, their main objective is to recover the debt that's owed to them.
Okay.
However, they can't just wake up one day and decide to sell. There are specific conditions, triggers that have to be met first before they can exercise this power.
Ah, okay. What kind of triggers are we talking about? What needs to happen?
So the CLPA lays out a few scenarios. The most common one involves notice. They typically need to send you a formal written notice demanding payment of the overdue amount.
A demand letter.
Precisely. And if you then don't make those payments within 3 months after receiving that notice, then they can exercise the power of sale.
3 months, okay.
Another trigger is if your interest payments are in arrears, basically overdue and unpaid for at least 1 month after they were supposed to be paid.
1 month for interest.
Correct. And finally, if you breach some other important provision in the mortgage agreement itself or in the CLPA, that could also give them the right to sell.
Right, so it's not like being a day late triggers an immediate sale. There's a process.
Definitely a process. Now, what happens once they actually sell the property?
Yeah, what then?
When the sale goes through, the mortgagee can legally transfer the ownership to the buyer. This transfer usually wipes clean any claims or interests on the property that came after your mortgage was put in place.
Okay.
But importantly, the sale is still subject to any claims or interests that existed before your mortgage, like maybe an earlier mortgage.
Prior interest stick.
Right.
And the money from the sale, where does that go?
There's a very specific order set out by law for distributing the proceeds. First things first, the costs and expenses the mortgagee reasonably incurred in actually carrying out the sale get paid.
Like agent fees, legal costs.
Exactly. Then the remaining money goes towards paying off your outstanding mortgage debt, the principal, the interest that's built up, any other costs allowed under the mortgage agreement.
Okay.
If, after all that, there's still some money left over, that surplus goes back to you, the original borrower, the mortgager.
Okay, that seems logical. But what if the bank, the mortgagee, doesn't follow these rules properly during the sale? Maybe they didn't advertise it right.
That's an interesting point. The law actually provides quite a bit of protection to the person buying the property in that scenario.
To the buyer. How so?
Generally speaking, even if there were some issues with how the mortgagee exercised their power of sale, maybe they didn't give the right notice or didn't quite meet that duty about getting a proper price MOFIT, the buyer's title, their ownership of the property, is usually still considered valid and secure.
Really? Even if the bank messed up?
Usually, yes. However, this doesn't mean you, the original borrower, have no recourse. If you suffered a loss because the mortgagee sold when they shouldn't have or because they didn't follow the correct procedures, you might have grounds to sue the mortgagee for damages for compensation for your loss.
Ah, okay, so the sale might still stand, but I could potentially go after the bank for compensation if they acted improperly.
That's the general principle, yes. It's also worth remembering that this power of sale isn't their only tool. They could also choose to go down the route of foreclosure through the courts, which is another, often more complex, legal process to take ownership and recover the debt.
Okay, wow. The power of sale is definitely a big one to understand. What other key rights do mortgagees have here in Singapore?
Okay, another significant one is the right to insure the property.
Insure it. Against what?
Typically against loss or damage by fire. After the mortgage is created, the mortgagee has the power to take out fire insurance on the property that's securing their loan.
And who pays for that?
Well, any premiums they pay for this insurance become an additional charge on your property.
Wow.
It gets added to your debt, essentially, with the same priority and carrying the same interest rate as your original mortgage loan.
So if I let my own insurance lapse, for instance, they can get their own policy and add the cost to my loan.
Pretty much, yes. But there are limits. If your mortgage agreement already specifies certain insurance arrangements, or if you, the borrower, demonstrably have adequate insurance already in place that meets the requirements, then the mortgagee's right to take out separate insurance might be restricted.
Okay.
And if there is an insurance payout, say there's a fire, the mortgagee generally has the right to decide how that money is used.
So.
They can typically require the insurance money to be used either to repair the damage to the property, restoring its value, or they can choose to apply it towards paying down the outstanding mortgage debt.
Right. Makes sense. They want to protect the asset that's securing their loan.
Yeah.
What if things get really difficult and maybe the property is generating income like rent?
Yeah.
Can they step in then?
Yes, that leads us to another power. The right to appoint a receiver.
A receiver.
That's right. If the mortgage money becomes due, meaning you're in default and it hasn't been paid, the mortgage usually has the power under the CLPA to appoint someone called a receiver.
And what does this receiver do?
Their job is to manage the income generated by the mortgaged property. So if it's a rental property, they would collect the rent.
Okay. And who does this receiver actually work for? The bank.
This is a really crucial point, and it often surprises people. Legally, the receiver is considered to be the agent of you, the mortgager, the borrower.
Wait, what? The receiver, who the bank appoints because I'm in default, is considered my agent.
That's correct. It seems counterintuitive, I know.
It really does. Why is it set up like that?
The legal thinking behind it is that the receiver is essentially stepping into your shoes to manage the property's income stream for the purpose of paying off the debt owed to the mortgagee. They aren't acting directly for the mortgagee in the sense of furthering the mortgagee's own business interests beyond debt recovery. Therefore, the borrower remains primarily responsible for the receiver's actions and defaults.
Huh. Okay, that's an interesting legal twist. So what specific powers does this receiver have acting as my agent?
They have the authority to demand and recover all the income from the property rent, for example, by taking action or legal proceedings if necessary, all in your name or the property owner's name. They can issue valid receipts for any money they collect.
Right.
And interestingly, the mortgagee who appointed them also has the power to remove them and appoint a new receiver if needed.
Okay. And how does the receiver use the money they collect? Is there an order for that too?
Yes, the law is very specific about how the receiver must apply the funds. There's a strict order of priority.
Let's hear it.
First, they pay outgoings, things like rent, if the property itself is leasehold, taxes, rates, and other charges related to the property.
Okay, basic running costs.
Then they pay any annual sums or interest on other loans that have priority over the mortgage they were appointed under.
So earlier debts get paid first.
Correct. After that, the receiver pays their own commission or fee for doing the job. Then they pay the premiums for fire insurance on the property, if any are due. Next comes the cost of any necessary repairs, but only if the mortgagee has specifically directed the receiver in writing to pay for them.
Ah, so repairs aren't automatic.
Not unless the mortgagee instructs it. Then, finally, the receiver uses the money to pay the interest that's currently due under the mortgage.
The interest owing to the bank that appointed them.
Exactly. And if, after all of those payments, there's any money left over the residue, it gets paid to the person who would have been entitled to the property's income if the receiver hadn't been appointed. Usually that's you, the borrower.
Okay, so it's a structured way to use the property's income to cover costs and pay down the mortgage interest first.
Precisely. Now, switching gears slightly, what about when you, the borrower, are actually ready and able to pay off the loan?
Yeah, say I want to redeem the mortgage early.
This brings us to the mortgagee's entitlement to notice. If you want to pay off your mortgage debt after the official date for payment in the agreement has passed, but before the term ends, the mortgagee is generally entitled to receive 3 months written notice from you about your intention to pay.
3 months notice.
Or, alternatively, you usually have the option to pay them an amount equal to 3 months' interest on the outstanding loan amount instead of giving notice. This is often called interest in lieu of notice.
Ah, okay. So either give them 3 months warning or pay 3 months interest.
That's the standard position under the CLPA, unless your specific mortgage agreement says something different. Some agreements might specify a shorter or a longer period or different terms.
Got it. Always check the agreement. Now, what if I don't just want to pay it off, but maybe I've found another bank willing to offer me a better rate? Can I force my current bank to transfer the mortgage?
Yes, there's an important obligation related to that. It's the obligation to transfer the mortgage instead of just discharging it in certain circumstances.
Okay.
If you, the borrower, are entitled to redeem the mortgage, meaning you're ready to pay it off, you have the right to require the mortgagee to transfer the mortgage debt and the security, the property, to a third person that you nominate.
So I can tell them, don't just release the mortgage, transfer it to this new lender.
Exactly. Instead of just reconveying the property back to you free of the mortgage, they have to assign the debt and transfer the mortgage itself to your nominee. This right isn't just for you. Other lenders who have a later mortgage on the same property, a subsequent encumbrancer, also have this right.
That sounds really useful for refinancing.
It is. However, there's a key exception. This obligation to transfer doesn't apply if the mortgagee is or has been in possession of the property.
Oh, okay. So if they've already taken possession, they don't have to transfer it.
Correct. Now, speaking of possession, what if the mortgagee does actually take physical possession of the property? Do they just sit on it?
Good question. Can they do anything with it, like rent it out?
Yes. If a mortgagee takes possession, the CLPA grants them certain powers to lease the property out.
Lease it. For how long?
They can grant agricultural or occupation leases for terms up to 21 years. And for building leases, say, if land needs development, they can grant leases for up to 99 years.
Wow, 99 years.
Yes, and these leases, made by the mortgagee in possession, are legally binding on any later mortgagees and also on you, the original borrower.
So if they take possession and rent it out, I'm bound by that lease.
Generally, yes. But there are conditions attached to this leasing power.
What kind of conditions?
The lease must reserve the best rent that can reasonably be obtained in the circumstances. They can't just give it away cheaply.
Makes sense.
Also, no upfront premium or lump sum payment, what lawyers sometimes call a fine, can be taken for granting the lease. And the lease must contain standard covenants from the lessee, like the promise to pay rent, and a condition allowing re-entry if rent is unpaid for a specified time, usually 30 days.
So they have to act like a proper landlord, essentially, getting market rent and using standard terms.
That's a good way to put it. Now, pulling back a bit, there's a really, really crucial point we need to be absolutely clear on. It relates to the mortgagee's responsibility or lack thereof when deciding when to take action, specifically when to use that power of sale we discussed earlier.
Oh, okay. This sounds important. Please clarify.
The established legal position, confirmed by courts in Singapore, is that mortgagees do not owe borrowers a general duty of care when deciding whether and when to exercise their power of sale.
No duty of care on the timing, really.
Correct. They are generally free to make this decision based primarily on their own commercial interests and the need to recover their debt. They don't legally have to consider whether the timing is advantageous or disadvantageous for you, the borrower.
So even if selling now means I get a much lower price than if they waited 6 months, they don't have a legal duty to wait.
Generally, no. That's the principle. The power of sale is a right they bargained for in the mortgage contract specifically to protect their investment and secure repayment. The law largely views the decision of when to exercise that right as being up to them. Think of it perhaps like this. If you owe a friend money, they aren't legally obligated to demand repayment only at a time that's most convenient for your finances. Similarly, the bank isn't legally obligated to time the sale of the mortgaged property to maximize your return. Their legal duty kicks in regarding the process of the sale to get a proper price at the time they choose to sell. But the choice of when that time is generally theirs.
That's a really critical distinction, isn't it? So the diligence applies to how they sell, but not necessarily when they choose to start that process.
Precisely. That's a very clear way to state it. So while they need to be careful and act properly during the sale to get a fair price then, they have considerable latitude in deciding when to pull that trigger in the first place, based on their need to recover the loan.
Okay. That clarity is very useful, even if the reality isn't always what borrowers might hope for.
It's important to understand the legal boundaries. And finally, we should probably touch briefly on what actually happens if things reach the point of court action.
Right. If you default, the bank might sue. What does that look like?
Yes. If you default on your mortgage payments and matters can't be resolved, the bank will likely commence legal proceedings. Often, this is done by filing what's called an originating application, or OA, in court.
OA, originating application. Okay.
This OA is basically the bank's formal request to the court. Typically, they'll ask the court for two main things: an order for possession of the property, meaning you have to hand it over, and an order for you to pay the total outstanding sum owed, which includes the principal, interest, and often their legal costs for bringing the action.
So I'd receive these official court documents.
Absolutely. And if you receive an OA, it is vitally important that you read it very, very carefully.
What should I look for?
Check all the figures meticulously. Do you agree with the amount they claim is outstanding? Are the interest calculations correct? Note down the date and time of the court hearing mentioned in the documents. You absolutely need to attend that hearing.
Okay, definitely don't ignore it.
Yeah.
What are my options when I actually go to court?
Well, depending on your specific situation, you have a few possible responses at the hearing. You could, if the debt is clear and you have no defense, consent to the orders the bank is seeking.
Just agree to it.
Yes. Or you could ask the court for more time. Perhaps you need time to try and sell the property yourself on the open market, hoping to achieve a better price than a mortgagee sale might. Or maybe you need time to refinance or find the funds to pay the arrears.
Can I propose a payment plan?
Yes, that's another option. You could propose a structured repayment plan to the bank, maybe even before the hearing, and present that proposal to the judge.
And what might the court decide?
The judge will listen to both sides, you and the bank's lawyer. They might adjourn the hearing, postpone it to give you more time to negotiate with the bank, finalize a sale, or arrange payments.
Okay.
But ultimately, if no resolution is reached and the bank has proven its case, the court is likely to grant the order for possession and the monetary judgment for the debt.
Meaning I'd have to move out.
Yes. The court order for possession legally requires you to vacate the property. Sometimes the court might grant a short grace period, say a month or so, for you to find alternative accommodation before the bank can enforce the order, but that's not guaranteed.
Wow. Okay, that's really sobering but absolutely crucial information. So the key takeaway, if you ever get court papers like an OA is, engage. Don't ignore. Read everything and show up.
Absolutely. Ignoring court proceedings is almost always the worst thing you can do. Engaging with the process, even if the situation is difficult, gives you the best chance to understand your options and potentially negotiate a less damaging outcome.
This has been incredibly insightful. Thank you. So just to try and wrap this up neatly,
Go ahead.
while mortgagees in Singapore definitely have significant rights, like that powerful right to sell the property if things go wrong, they aren't completely unchecked.
That's right. They operate within legal boundaries.
They have that duty, that equitable duty, to make reasonable steps to get a proper price during a sale process itself.
Correct. Focus on the process at the time of sale.
However, and this is the crucial bit we clarified, they generally don't have a broad legal duty to consider the borrower's best financial interests when deciding when to initiate that sale. that timing decision is largely theirs.
That sums it up very well. Their primary focus, legally sanctioned, is the recovery of their debt. And as we just discussed, if default occurs, court action is a real possibility, making it vital for borrowers to understand the rules and participate if it happens.
Absolutely critical. And, of course, a really important reminder for everyone listening, every single mortgage situation can have its own unique facts and nuances.
Definitely.
So if you are facing difficulties with your housing loan or you're unsure about anything in your mortgage agreement, please seek independent legal advice from a qualified lawyer who can look at your specific circumstances.
That is always the most prudent step. So thinking about everything we've covered, understanding these fundamental rights and obligations, how might this knowledge actually empower you, the listener, to navigate your own property journey here in Singapore more confidently, more awarely?
That's a great question for everyone to reflect on. Food for thought. And that brings us to the end of this deep dive into the sometimes complex world of mortgage rights and obligations in Singapore. We hope you found it useful.
We do.
Remember to like this deep dive and subscribe to Singapore Property Talk Law for more insightful explorations into Singapore real estate. Thanks so much for tuning in.
Thanks, everyone.